Hello, everyone. Good afternoon. I hope everyone's great this afternoon. We've got a slightly heavier topic this time. As you can see, conflict of interest, conflicted remuneration, nothing very positive even in the titles. But we've got wonderful guests today, and I'm sure they're going to try to make it as easy, as fun as possible. All right, so let's get started on this. So my name's Tatiana George. I am the CEO and co-founder of Curium. As you probably know, Curium is a technology platform first, but also very much an enthusiast of everything related to risk, compliance, and claims. All right, so today we've got two wonderful guests, Yvonne and Michaela, and I'll let them introduce themselves.
Thanks very much, Tatiana. Good afternoon, everyone. My name is Yvonne Lamb. I'm a partner at international law firm Clyde & Co, and I specialise in advising the insurance sector on corporate insurance and regulatory matters. Pass on to Michaela to introduce herself.
And I'm Michaela. I also work at Clyde & Co as Senior Associate with Yvonne, but I specialise in regulatory and investigation matters. And I joined earlier this year coming from an Australian regulator.
So first-hand knowledge, guys. All right, so what we're going to walk through today, we decided to give you a little reminder of what actually happened last year, but it feels to us, talking to a lot of you in kind of closed rooms, it feels to us that a lot of, first of all, legislative changes and then regulatory changes did not really land anywhere. And because there was so much noise about other things that potentially they might have been missed. So we decided to kind of draw your attention to something that already happened last year and where you already should have kind of formed opinions and potentially modifications to the way you do things. So one of those things, we're going to walk through the reform of conflicted remuneration. That's a legislative change that happened last year. Then we're going to look at implications of that reform in the insurance industry. You probably have heard about one aspect of it potentially too much, which was the informed consent for commissions for brokers and advisors. But there's kind of a lot more to it. So we'll deliberately not dwell on the informed consent today, but focus on other areas which could have been missed due to that noise. And then we're going to go into the changes to management of conflict of interest. And the trigger for that was the updated ASIC guidance that came out late December last year, obviously just before Christmas. So we feel like a lot of people could have missed it. Before we start, can I just ask for your opinion? So you kind of, you've showed up for the webinar today. So obviously there's something that prompted you to do this. But we would like to run a very short, quick poll. It's all anonymous, just letting you know. It doesn't register who you are. But we'd like to understand how confident are you in the fit for purpose of your framework today? And when I mean, can you see it? Just checking. Can you see the poll? Yeah. Okay. So, and when you think about a framework, don't think just as a theoretical thing, okay? Think about as something that's working and something that you've seen, you've seen somebody reporting a conflict, you've seen somebody kind of dealing with it, managing it, and so on. So just give us a sense. Possible, please? Okay. Right. So a lot of people are fairly confident, somewhat confident. Okay. Not extremely confident, somewhat confident and neutral. Okay. Look, all full disclosure, we're going to run this poll twice. We're going to run it now, and we're going to run it at the end again. So you'll see kind of where you land. So just as of now, 56% of people are somewhat confident. Only 6% of people are very confident. And roughly 1/3 is neutral, not sure, I guess. All right. Sorry, did I share this? You can't see it, right? You can't see the results of that. All right. So roughly 55%. Okay, we're landing at this. Thank you. So now let's dive into this topic, and I'll pass on to Yvonne to walk us through the recap of the reform on conflicted remuneration from last year.
Thanks, Tatiana. So as Tatiana mentioned earlier, there has been legislative reform, but the core of the conflicted remuneration ban is not a new obligation. It's been in our Corporations Act since 2012. It's gone through some slight changes in that time. But the key thing is that most insurance products have been exempted through a number of different provisions. And it's only really until the informed consent requirements for commissions were for personal advice, where it's given to retail clients, came into effect last July, that we started looking at this more closely as an industry. So we'll talk a little bit more later in this session about how these exemptions for the insurance industry now operate across different types of insurance products, which might affect you all differently depending on which part of the sector you work in. But in a nutshell, under the ban, AFS licensees and their representatives are prohibited from accepting conflicted remuneration, while employers of licensees, product issuers and sellers are prohibited from giving conflicted remuneration under the Corporations Act. If you're a licensee, you also have an obligation to take reasonable steps to make sure that your representatives do not accept any conflicted remuneration. And at a high level, the purpose of this prohibition is really to improve the quality of advice and other financial services that retail clients receive in the market, and to build trust and confidence in the financial services industry as a whole. So ASIC obviously takes a pretty close regulatory scrutiny in this area because of that purpose, and they have issued a regulatory guide 246, which talks a bit more about their expectations in terms of how you approach the ban on conflicted remuneration. Now, in terms of consequences, if you do end up breaching the ban, there are different types of consequences that possibly could attract, say, administrative sanctions from ASIC, so things like banning orders, but also some penalties. So there has been a recent example of this in action where ASIC brought federal court proceedings against a licensee called RM Capital and its authorised representative, the SMSF Club, which then resulted in some court orders that were handed down last December for the licensee to pay a $575,000 penalty. And also the representative was issued with orders to pay a $350,000 penalty. And this was in relation to some conflicted remuneration breaches where the licensee had failed to take reasonable steps between August 2013 through to August 2016 to make sure that its representative didn't actually accept any conflicted remuneration. But the court found that during that period, the authorised representative did actually accept conflicted remuneration on a number of occasions for referral fees that came from a real estate agent. So you can see ASIC is quite active in this area, and we'll step through now on the next slide. So just a bit of a recap on the key concepts that underpin this ban. So with all that in mind, we'll start with what it constitutes conflicted remuneration. At a general level, under Section 963A of the Corporations Act, we set out the definition. So you'll see that it includes any benefit, whether that's monetary or non-monetary, that's given to a licensee or representative who provides financial product advice to persons as a retail client, where that could reasonably be expected to influence the choice of financial product recommended or the financial product advice given. So that means that the ban restricts any giving of conflicted remuneration in that context. And the triggers we're really looking at are where there is financial product advice that's provided and if you're dealing with retail clients. And really the test is whether that benefit would reasonably be expected to influence the choice of product or advice that's provided. It's an objective test, so whether the benefit is capable of meeting that criteria will just really depend on the nature of the benefit or the circumstances in which it's given or accepted. Now, given the trigger is financial product advice, we thought it's also useful to set out what constitutes financial product advice. So this is the definition really captures anything that's a recommendation or a statement of opinion or a report of either of those things where it's intended to influence a person in making a decision in relation to financial products or a class of financial product, or it could reasonably be regarded as being intended to have that type of influence. And there are two types of financial product advice, as most of you are well aware. We've got personal advice, which is financial product advice that's given or directed to a person in circumstances where the person who's giving that advice is considered one or more of the client's objectives, financial situation and needs, or a reasonable person might expect that the person who is giving that advice has considered one or more of these matters. So take more tailored advice. Anything that is not personal advice is considered to be general advice. So we'll just move on to the next slide, please. One thing that we do want to flag is that that definition of conflicted remuneration we just ran through, that applies generally across the board, no matter what type of product you're dealing with. But there are specific circumstances that are set out under Section 963AA of the Corporations Act and further prescribed in our regulations, where you're dealing with benefits that are given in relation to life risk insurance products. So under this arrangement, these particular benefits that we've set out on the slide are considered to be conflicted remuneration when you're dealing with life risk products. And so you'll see that this includes any benefit, whether that's monetary or non-monetary, again, that's provided in response to information on or dealing in a life risk insurance product. And the key thing here to remember is that it captures even where advice is not provided. So all that is required here is that there is information given to a client, and that's a retail client, or you're dealing in a life risk insurance product. But it only applies where it's the access or amount of a benefit is dependent on the value or number of life risk insurance products that are being acquired or varied. So it's quite specific. We just thought we'll call that out because it depends on what type of product you're dealing with. And we'll come back to this later on in the presentation once we cover a few of the exceptions that apply across the industry. Right. Just move on to the next slide. Thanks. So benefits. As I've mentioned already, there's two types of benefits. It can be either non-monetary benefits that we're talking about or monetary benefits. We might just start with non-monetary benefits. ASIC has provided a list of examples of the different forms that non-monetary benefits can take. And that includes things like free or subsidised business equipment or services, computers, hardware, software, that sort of thing. There's also things like hospitality-related benefits, where we're talking about, say, tickets to sporting events or concerts, subsidised travel. Shares or other interests in a product issuer or licensee are also considered to be non-monetary benefits. And other things like marketing assistance might also be captured in that category. And then if we turn back to monetary benefits, that's a little bit more obvious. So the different types of monetary benefits can include commissions that are paid by a product issuer to a licensee. There might also be volume-based payments from a platform operator to a licensee, or it can also take the form of discounts on fees that might be paid by, for example, an authorised representative back to its licensee. That might be based on funds that are held in a particular financial product that's issued by a related party. So here, what's important to remember is that it's only really benefits that can influence advice or potentially the information that's given for the life risk insurance products category that we talked about, that would be considered conflicted remuneration where you're dealing with retail clients. So on the flip side, if it's a benefit that doesn't influence advice, then it's not likely to be classed as a conflicted remuneration piece. So here ASIC does give guidance that salaries and your usual business expenses are not considered to be captured in this category as conflicted remuneration. There's also a couple of specific exclusions. So one that might be quite relevant is where there's benefits that are given or authorised by the client directly. So here, under that exclusion, any monetary or non-monetary benefits would not be considered to be conflicted remuneration, where it's actually given by the client or someone who is acting on behalf or authorised by the client to give that benefit on their behalf. So it needs to relate to the financial product or service that's being provided, and it can be given potentially from the products that the client has rights or benefits. So this can include where a benefit might be paid out of a premium, which is paid by the client, so where the commissions are taken out of that, or fee-for-service arrangements. So that exclusion will then apply in that situation. There's also another small value non-monetary benefits exclusion. So we're talking benefits that are less than $300 will not be classed as conflicted remuneration. But you do need to make sure that if you're a licensee, you're keeping records of those benefits with that value between $100 to $300 that are given to you as a licensee or any representatives that are providing advice. And then lastly, there's also exclusions where you might be giving training or educational courses that have a genuine educative or training purpose that's relevant to your carrying on a financial services business. So that would then also be considered to fall outside of the scope of that conflicted remuneration ban. and also where you might be providing IT software or support in relation to financial product advice for people who are retail clients. That's also outside the scope of the ban. So there are various exclusions, and that applies across the board for all non-monetary benefits. So if we can just move on to the next slide, this is where it starts getting a little bit more complex depending on where in the sector you are. So here we've just set out the product-specific exclusions from the ban. So here, if you're in general insurance, good news is that there are more specific exceptions for both monetary and non-monetary benefits where you're giving solely in relation to a general insurance product. So that's for general insurance products. Then where you're dealing with consumer credit insurance, there is an exception, but it's only in relation to monetary benefits. Then we get to life risk insurance products where monetary benefits that are given in relation to that class of product is only exempted where they're not a group life risk policy for a superannuation fund or an individual life insurance policy for the benefit of a member of a default super fund. And the benefit needs to be a level commission, or the benefit ratio requirements and clawback requirements specified by ASIC are satisfied in relation to that benefit. So quite prescriptive. What's very important to remember now is that all of these exceptions on a product level for insurance are still subject to those informed consent requirements that came into effect last July. So what that means is that if you don't comply with the informed consent requirements, then the conflicted remuneration ban exception doesn't apply for that product.
So maybe just very specific what that means. If you are providing personal advice and you did not collect the consent from the customer before, then whatever you receive is going to be deemed conflicted remuneration, correct? Roughly.
That's right. Well, we're talking about monetary, so correct, commissions.
Yeah. Commission, yeah.
And you're giving personal advice, you're dealing with a retail client, you didn't go through the informed consent process beforehand, and yes, that does mean that you will end up with a contravention of the ban on conflicted remuneration.
But on the flip side, if you received consent from the customer, then that's it. Then none of this applies to you, correct? Just kind of simplifying it.
Yes, that's right. So maybe it makes sense if we go to the next slide, because we do try to display it a little bit more simply what happens there. So you'll see in the different types of products we just talked through what happens in terms of whether you're dealing with monetary or non-monetary benefits. So for general insurance product, it's fine. There's an exception for both non-monetary and monetary, but it's for personal advice. Sorry, that's monetary for general advice. But when you deal with monetary benefits for personal advice, it's only if you get the informed consent before your commission's received that you don't need to comply with these requirements. But on the flip side, if you don't receive that informed consent beforehand, then the requirements apply. For life risk insurance products, it's a little bit more complicated, as we mentioned, but some of the same concepts do apply in the sense that if you don't get that consent, you will have requirements applying to you here. And then in life risk insurance and consumer credit insurance, there's no exception for non-monetary benefits, but that is then bound up in the exceptions I talked about earlier about small value, or whether the non-monetary benefit might be dealing with a training or education purpose, or might be part of IT support that's being provided. So those things still do apply in that context if it's relevant to the situation. So I think key takeaway, it's a little complex, but the key takeaway is that the informed consent requirements have become even more critical in this post-July 2025 environment. So without that consent being provided before you issue or sell insurance, if you've got commissions and you're dealing with personal advice that's given to a retail client, monetary benefits, the commissions will not fall outside of the conflicted remuneration ban. And the consequences that we talked about earlier will then be attracted in that situation if you don't have the right frameworks in place. So it is essential that if you are already reporting consents from your clients as a result of those reforms from last year, you're keeping those as part of your written records if you're a licensee and if you've got representatives working under your license to make sure you can demonstrate compliance with those obligations. So I might pass back to you, Tatiana, on that note to just take through.
Just maybe a few clarifications before we wrap up here. So just break it down again. So those things apply for people providing advice. And realistically, what that means is brokers and advisors, so financial advisors, okay? So if you're providing general advice, what applies?
If you're providing general advice, then it's okay from, you don't need to get the informed consent requirements because it's only where you've got personal advice.
Yeah, and does the ban apply or does the exception on the ban apply on conflicted remuneration?
So if you're dealing with general insurance products,
Correct.
the
Yes.
exception applies.
Correct. Okay. So general insurance, general advice, you're accepted from the ban on conflicted remuneration. Personal advice, no consent, you're not, you're fully in. Personal advice, consent, yes, then you're accepted again. Okay.
That's right.
It's kind of
quiz. We can develop a quiz post session to see if you get the different variations right, but that's right.
Yeah. For life insurance products, my read is it's kind of applying pretty much across the board with very little room for exceptions. And then for consumer credit insurance, I would say the same rule as for general insurance applies, more or less.
Yes, except there isn't a full exception of non-monetary benefits from the ban. Yeah.
Okay, so that's for those who provide advice. What about those who do not provide advice, or product issuers?
Well, I think there you need to take a look at whether you might be creating anything in your distribution channels in terms of what you're providing on your commission structures and your incentives, because on the flip side, those that you're engaging with might be subject if there is advice in their model, but it's only the life risk insurance products that I mentioned where no advice is given and you just provide information that there might still be some risk involved in that situation.
Yeah. Guys, please feel free to post your questions in the chat, or I think there's a Q&A. I know it's a complex topic. We're trying to simplify it, so please. So my Q&A is not loading for some reason. Let me move on to, okay, here, there's a question, Yvonne, if that's okay. Does the ban only apply to retail clients and specific domestic classes of insurance?
Yes, it is retail client specific. That's right. Yeah. Not sure what you're talking about in terms of the domestic classes of business. You might be talking about the classes of business that are linked to retail general insurance products. And that's
what, yeah. Okay, cool. Let's just abstract a little bit and say, well, what does that mean for you in general, more or less? What does that mean? So, okay, so general insurance exemption is not a blanket, okay? It does not guarantee, so the moment you work in general insurance, that's it. So that's not the case. So general insurance is not fully out, as we are trying to demonstrate here with various examples and just clarifying things. Somebody here saying, can you please bullet point the summary of requirements you just eloquently summarized? I'm not sure. I'll try. If not, I'll try to do it in the write-up post this webinar, Chris. Thank you. Okay, so general insurance is not out as a blanket rule. There are parts of it that are in, and I'll try to summarize it. What's in is personal advice for retail clients, okay? And there are ways out of it. And the way out of it is the informed consent before you receive a commission. It's kind of very, very simplistic summary of what we've just heard. Okay, then consent becomes critical. This is what Yvonne was trying to tell you, is that the reason we kind of dwelled on it so much last year, and a lot of people got really fed up with this, was because it's so critical and because it kind of helps people to get out of this conflicted remuneration ban altogether. Advanced classifications matter more than ever. Again, goes back to the point, are you in or are you out? Are you providing general advice or not, or personal? A big distinction here again. Then each commission scheme or incentive structure needs to be reviewed. And what that means is for both product issuers and product distributors. So Patrick has a hand. I'm not sure we can enable your mic. So if you could just please paste or put your question in the chat, that would be easier. Any scheme, any remuneration, any incentive, it needs to be reviewed on both sides. Who is the one providing it, but also who's the one receiving it. So you kind of need to have it on both sides of the equation. And both of you will have licenses, right? So both the distributor and the product issuer will have a license, and this ban works on both of the licenses. So the product issuers are not allowed to provide conflicted remuneration on their part. So don't forget that. Next one is non-monetary benefits are not harmless. Absolutely. We've kind of seen that before. And the importance of all of your gift registers, gift policies. Also, you've seen the $300 thresholds. So don't forget, this is important for you to know, okay? Question is, have you breached the ban or not? Is almost a secondary one if you don't know and if you don't have a register and can't tell. And then finally, evidence and data become critical. So ASIC is updating those things and guides for purpose, and ASIC will come looking for, what people do. And don't forget, we're going to come back to kind of broader conflict and perception a bit later in the second part. Michaela will walk us through, but I'm just kind of jumping ahead here and saying evidence becomes very, very critical, because we observe a lot of people almost carelessly doing a lot of social media sharing. And if I were ASIC, I would go and start there, because there's a lot of at least perceived conflicts, okay? And it's all in your face a lot of the times. So if that's happening, you need to have a proof that you are controlling these things, that you've informed your employees about what's allowed, what's not. You've also identified potentially maybe like a gray zone or something that's allowed but needs, a sign off from a manager or something like that. But the more you know and the more you can demonstrate, the better it is for you. All right. All right, cool. So move on to the broader conflicts of interest. Pass on to Michaela, but as you can see, it's not as easy, unfortunately, as a kind of blanket statement. So please keep posting your questions. And if there are more questions after that, just let us know, because when we'll try to write up something or make like something slightly simpler for you to go from. All right, Michaela.
Thanks. And unfortunately, Tatiana, I'm not going to make this easier when it comes to remuneration, because whilst there is the exception to the remuneration for insurance, it gets a bit tricky when we deal with the overarching obligation that AFSL licenses and their representatives have to manage conflicts of interest. So I'm sure you guys all know it, but just to reiterate, there's an obligation in 912A of the Corporations Act that AFSL licensees have in place adequate arrangements for managing conflicts of interest that occur in relation to activities undertaken in the provision of financial services. So a conflict of interest is when there are competing interests. They can be personal, financial, business, or party related, that either direct or indirect interests that arise in a particular situation that may impact or interfere with your fair, objective decision making. It's very broad. The obligation is not to eliminate all the conflicts. That's the ideal standard. And if you want to do that, that's great. But it's not to eliminate everything, but rather it's an obligation to adequately and effectively manage conflicts, which for the purposes of reducing the risk of consumer harm and improving building on market integrity. So why are we talking about this now? As Tatiana said, in December, ASIC reissued its regulatory guide on conflicts of interest. And it's the first time they've done that since 2004. So it was a pretty substantial update. And in making the update, ASIC said that it considered conflicts of interest to represent a significant source of misconduct and cause of consumer, investor, and economic harm within the financial services sector. So they think it's a serious issue. The revised guidance, the obligation does not change, but what has changed is how ASIC expects you to meet the obligation. It's essentially a fundamental shift on how you should all be preparing, how you should be making arrangements to manage conflicts of interest. So the conflicts of interest obligation, the courts and ASIC have consistently said that what it requires is four steps. You need to proactively identify conflicts of interest. Then you need to assess and evaluate the conflict of interest before deciding on and implementing appropriate response to that conflict of interest. Then throughout the life cycle, you then need to monitor and manage the response to ensure that they remain adequate. So arrangements, what do they include? It's generally a combination of things, but policies and procedures, people and resources, so certain staff with responsibilities over conflicts, but also staff training, systems and control, governance and supervisory arrangements, so structures, reporting structures. What do you do when a representative, receives information that could be a conflict? Who do you tell? What's the next steps? Those are what arrangements are. Now, before we talk through the various steps to developing adequate arrangements, there are some key overarching comments that ASIC has made that expects you to comply with in relation to this obligation. The first is that for conflicts to be adequate, for complex arrangements to be adequate, they must be tailored to the business's circumstances. Just back one. Yeah, sorry. Tailored to the business's circumstances. You can't have generic policies, and it needs to depend on the facts and circumstances of each business. So that includes the nature, scale, and complexity of the business, the breadth of the financial services offering, as well as the type of clients that you're dealing with, wholesale or retail. Secondly, the scope of the obligation is broad. It applies to all conflicts of interest that touch on the financial services business. ASIC has said that it cuts across the regulated population and intersects with other legal obligations. It's intended by Parliament to be a principles-based obligation that is supported by ASIC's guidance. It's very broad. The third key change, which I just touched on, which is that the conflict management obligation is an overarching obligation which intersects with other legal obligations that licensees have. So within the licensee obligations, such as the requirement to act efficiently, honestly, or fairly, and have risk management systems, but also outside of your licensing obligations. So I'm talking about here, if you're also regulated by APRA, compliance with prudential standards, potentially compliance with codes of conduct, or obligations that you have generally in terms of fiduciary duties, or if you're a director, director's duties. So there are a number of other legal obligations that are relevant to the conflict of interest obligation, because the conflict of interest obligation applies to a broad set of conduct. That needs to be considered when going through the process I'm about to take you through of determining what adequate arrangements are to manage conflicts. So the first step, which is on the next slide, which is identifying conflicts or classes of conflict, okay? So that requires a consideration of what interests that have a real and sensible possibility of swaying a licensee or its representative, their judgment or actions in an adverse way. So ASIC says that conflicts can be one of two things. They can be actual, which is a real conflict that currently exists that could sway your judgment or action, or potential. So this is where circumstances that don't currently exist but currently give rise to a conflict, but they reasonably could be expected to. So perceived conflicts, like reasonably perceived conflicts. When identifying conflicts, ASIC has now made it clear that it's an objective test. So it's a common sense objective test, and you've got to think about what a reasonable person in the situation would do. Would they consider that to be a conflict? And I know it's very Australian of me to say, but it's basically, does it pass the pub test? Okay. Tetiana will provide some more examples in a second about the examples of conflicts, but ASIC has been, in terms of financial services industry, ASIC has given 7 good types of conflicts that licensees should at the very least consider when identifying potential conflicts in the business. And that includes conflicts with clients, conflicts between different clients, conflicts within the structure of the business or the corporate group, conflicts in relation to a client's proprietary information and the use of that information, conflicts relating to other duties competing duties that you may have, so fiduciary duties, director's duties, or other professional duties, conflicts in relation to third parties and interactions with third parties, and then, very relevantly, individual conflicts. So thinking about competing interests of the business with individual interests, financial, personal, and other loyalties and obligations. So those are the 7 types of conflicts that ASIC say you need to at the very least think about. And when you're thinking about those types of conflicts, ASIC has also identified 5 factors that are really relevant when identifying conflicts. And that is confidentiality. So confidential information, the access to and use of confidential information. I'm sure everyone knows about insider trading, but that's a classic example. Conflicts of duties. So when there's competing duties, as I previously mentioned, the structure of a business and whether that gives rise to potential conflicts, third-party commercial relationships, and finally, remuneration, which is what everyone's just been talking about. Whether there's incentive remuneration that may give rise to a competing interest, so they need to be considered about, even if you are exempted from the prohibition on conflicted remuneration. So you need to think about circumstances such as consumers being sold financial products or services that are not in their interests that perhaps may maximize your commission, or customers being charged unnecessary fees or excessive expenses. Tatiana, did you want to go through some examples at this point?
Yeah, let me just launch another poll. And again, it's just an interesting one. So if you think about your businesses, okay, and if you say, well, now that I know all of these different categories, where do you think in the business is a conflict likely to happen? Or obviously we want to see the unseen ones, meaning the ones that are potentially not in your face, but where do you think it actually happens? Just if you can, let us know. It would be very interesting to see what people really think. Incentives and remuneration and third-party relationships, the two winners as of now. Please have a look and just make your pick, because it's almost like a self-test for you, not necessarily for us, but to see where is the conflict now that you know all different things that can happen, and then we'll move into examples. Okay, so I'll start on the examples, and I was trying to be very careful not to be, like, don't shoot the messenger, please, in this one. So I've stayed very, very close to official ASIC guidance, but offline I can tell you a lot more. Okay, so a broker recommending a product to the client that has a high commission, and as Michaela was just saying, is not necessarily in the best interest of the client. That's a very, very classic one. And it's being cited and quoted by ASIC as almost number one example of what it will consider conflicts of interest. Then in our little poll, we've got third party and insurer relationship as being the absolute leader where they happen. So yes, absolutely, that's where they happen. So a supplier to the industry providing a better service to someone like an insurer, agency, broker, or whoever else who also has a shareholding with them. So effectively, it's like a preferred supplier kind of relation where, if you hold ownership or some kind of, well, mostly it's ownership, shareholding, and then, your clients will come first, but then it means for everyone else, their clients will come second. So the conflict is obviously for the supplier providing that service. Then a director of both a general insurance, for example, and an advertising agency, or plug anything you like, but any third-party vendor involved in deciding which vendor to select, right? If a director has kind of either directorship or relationship in both, again, that's a conflict on the other side. That's a bias on the side of who you're selecting. And then an example of a personal one, because, I think, funnily enough, people are very conscious about especially shareholding and director positions, but they forget about real people doing the job. And again, I've seen a lot of those. A claims officer, as an example, making a decision on a claim, which has to do with their close relative or friend or something. Right. So in those cases, again, there's a direct monetary benefit potentially that can go to somebody who's closely related to the person. And practically speaking, I have not really seen functioning kind of proper mechanisms and framework that would control for those, you call it small conflicts, right? Not on the board level and not on the kind of management executive level. So you just, as I said, stayed very close to ASIC. Not throwing anything explosive in there. Back to Michaela.
Thanks, Tatiana. I think based on what ASIC is saying is that conflicts are so dependent on the circumstances of a business. So it's actually quite hard to give really general examples beyond the really obvious and serious ones. But so another change that ASIC has made to how we implement the obligation of conflicts is its expectation that you develop a proportionate and risk-based framework for managing and responding to conflicts. So this goes back to their overarching comment that the framework and the arrangements need to be tailored to the business. It's personal. So after identifying conflicts, you need to then assess the conflict and assess and evaluate it, and then determine the appropriate response. And that requires essentially, firstly, with assessing a risk assessment. So you need to weigh the risk of the conflict against in the context of the circumstances of the business. So when we're looking at the risk of a conflict, we're considering the seriousness of the conflict, the nature of the relationship between the parties, the scale of the conflict, the likelihood of the conflict actually occurring, the potential or the actual harm as a result of the conflict, whether similar conflicts have occurred in the past, and how the business could actually reduce the risk of the conflict. So how could they implement controls to mitigate that risk or the likelihood of it actually eventuating into an actual conflict? So that assessment then needs to be weighed, as I said, in the context of the business. So that's looking at the nature, scale, and complexity of the business and the risk in the context of that. But also, as I mentioned earlier, it needs to be looked at in relation to the licensee's other legal obligations and whether there's a conflict as a result of that and the seriousness of that conflict as a result of that. So once that risk assessment is done, and so arrangements need to be throughout. So there needs to be an arrangement, including like a policy or procedure of how to assess a conflict at that point. And once you've gone through the process of doing that in accordance with the policy, you then need to consider how do we best respond to that conflict in light of the assessment of risk. So, and ASIC has been very clear here, and as has the courts. Everyone, up until now, most people just disclose the conflict to the client or, put it in a PDS, you just disclose it. ASIC saying that is not enough, and you can't just rely on disclosure. There needs to be a combination of 3 things for effective conflict management, and that is deciding when to avoid a conflict. So avoid a conflict, control a conflict, and then disclose a conflict. And sometimes you need to do more than one thing when responding to a class of conflicts. Okay, so let's go through them. So avoiding a conflict. This will occur in 2 situations. The first one is when you are responding to an actual conflict that's serious and it cannot be managed by controlling or disclosing. And, essentially this is when the business draws the line and when it does not act, when it's so serious. And the second one is when you have proactively identified potential conflicts and implementing a way to avoid the conflict. So that's when you avoid the potential conflict by, for example, implementing a control, which we'll talk about in the second aspect, which is such as an information barrier to restrict all functional separations of teams. So those are the 2 situations where avoiding comes up. ASIC has been very clear, however, and it's rare for them to be very clear. Usually they'll say, it depends on the facts and circumstances, which can be frustrating at times, but they are very clear in 2 respects of when you should avoid a conflict of interest. And they've given us 2 situations when you should absolutely avoid a conflict of interest. First one is when the interests of a client are in direct conflict with an interest of another client. That's when you must avoid a conflict. And the second is when remuneration practices place the licensee or its representatives, their interests in direct conflict with the interest of a client. So that's the first example that Tatiana gave about commissions and recommending products. It's in direct conflict. Okay, so that's avoiding. And really businesses need to figure out and determine based on their own risk appetite when they draw the line and when they do not act in relation to potential conflicts. The second one is how do you control the conflict? Basically implementing controls to mitigate the risks associated with the conflict. So that would look at, things like information barriers, functional separations of businesses, removing of individually conflicted staff from a certain client or a certain transaction. In situations where there have been identified conflicts and they're being managed, it could involve certain approval requirements for when providing those financial services, or there could be increased compliance monitoring of that sort of transaction or client. So those are examples that ASIC gives of controls, and the reg guidance actually provides a lot more. So it's quite practical in that respect. The third one, disclosing conflicts of interest. ASIC and also the courts have been really clear that if you are to disclose a conflict of interest, it must be made in a timely, prominent, specific and meaningful way. Disclosure must allow affected parties to understand and time to consider the impact of the conflict before they make an informed decision about what they want to do. So you can't disclose a conflict after someone decides to acquire a product, and you can't do it in a way that obscures, like put it in the middle of a terms and conditions or a PDS so the client's unlikely to actually understand that there is a conflict there. It needs to be very clear, and it needs to be specific. You need to provide specific information about the conflict so that there is no doubt.
Just jump in here.
Yeah.
Jump in here. So again, please don't shoot the messenger, but think about your FSGs, because that's one of those places where, at least personally, I see a lot of conflicts being disclosed, but very, very tiny font, like page 2 at the bottom kind of thing. So is that acceptable, Michaela? Just asking the expert.
I'm going to give an ASIC answer. It depends on the facts and circumstances. But I think if it wasn't pointed out to the client that the FSG did identify certain conflicts and that wasn't documented, I think it would be hard to say it was effective conflict management. Okay. But and on the point of disclosure, ASIC and the courts, and so there has been a number of federal court cases. I should have said this earlier. There's not been a number of federal court cases which has basically set out factors that are relevant and are required in order to meet the conflicts obligation, and ASIC has incorporated that into Reg Guide 181. But essentially, in relation to disclosure, what they also say, ASIC and the courts have said that there can be limitations to the effectiveness of disclosure. So generic disclosure, such as like a generic line in an FSG, is unlikely to be effective because it won't put the customer in a position to make an informed decision, or it's unlikely to. If it's in tiny font at the end of an FSG, how are we confident that the customer has read it, understood it, and made an informed decision in relation to the conflict? And also, excessive disclosure can not be effective because it obscures or distracts from the actual issue and the seriousness of the conflict. So disclosure can't be used all the time. You need to carefully consider when disclosure is appropriate. And if you decide to use disclosure, you need to be specific and clear in that disclosure. Okay. So that's basically taking you through the roadmap of how ASIC says you need to develop adequate arrangements to meet your conflicts of interest obligation. In addition to the, identify, assess, respond, you've also got to monitor and review the appropriateness of your arrangements, because businesses aren't static. Things change. Regulatory obligations change. Business operations change. So they need to be consistently reviewed. But practical takeaways. Tatiana, I know you're going to go into these in more detail, so I'm going to just give like some high-level thoughts. But essentially, what I guess I take away from the revised Reg Guide is that adequate arrangements require more than a raft of generic written policies and disclosure. They need to be robust and tailored to the specifics of the company. And those arrangements need to be integrated into your business operation. What's also required is your representatives need to understand the conflicts of interest obligation and the requirements of them, so that it is front of mind when a situation arises, as I say, that might, cause some concern, the pub test. The obligation interacts, the second point is the obligation interacts with other legal obligations. And this is how we tie back into the point and make conflicted remuneration more complicated. Whilst there is exceptions to conflicted remuneration, the ban on conflicted remuneration, ASIC has been specifically called out that conflicted performance-based remuneration or incentive remuneration may still cause a conflict of interest, and that needs to be considered by a business if the performance-based remuneration creates misaligned incentives, can influence behaviour, or give rise to unmanaged conflicts which require mitigation or escalation. Expectations.
Just on that, Michaela, to be clear, so what I talked about earlier in terms of the conflicted remuneration piece, there's specific exemptions that relate to products. There's specific things that trigger from whether you're giving personal advice to retail clients or not. But what Michaela's talked about here, the general conflicts management obligation, that's not specific to any products or specific to your distribution model. So it applies across the board to all license holders and representatives in terms of the management obligation for conflicts. So that's the key takeaway. I think that while there are certain things that might only affect you depending on where in the sector you operate in respect of conflicted remuneration, the conflicts of interest management obligation is across the board. which is why it's important to make sure you have the right frameworks in place.
Yeah, exactly.
Can I jump in and give, I can't kind of withhold that almost, and give an interesting example. So let's say you're a broker, and let's say you fall under a lot of those exemptions for conflicted remuneration, but then you post a photo of yourself at some very, very high-end function organized by the insurer. Okay, and it's clear that that function has cost more than $300 per head. Something like, a VIP lounge in a big sporting event, or like a yacht in the middle of Sydney Harbour, something like that. So even if you're all clear on all the, different conflicted remunerations and obtain your sign-offs from your, managers and stuff, the perceived conflict is in your face. Because people will see it, right? People will see what you do and how you do. And next time you advise a client and suggest the policy of that insurer, it's kind of in your face. So I hope that's.
And I think in those circumstances, you need to know to consider, is there a real or sensible possibility that this situation may sway my judgment, or sway how I make a decision? And I think that's where the potential for a conflict sits there. Okay.
Sorry.
Yeah. No, the only other thing I wanted to say was that moving forward, I don't want to scare anybody because it's been a pretty heavy and serious topic, and it's not easy, as I think we've demonstrated. ASIC has made it clear that this is not something that there's no transition period for this updated guidance. Actually, a number of industry bodies asked for a transition period to allow licensees to get up to speed with the requirements, and ASIC has said no, which indicates to me that ASIC is not going to sit on its hands. It's going to move, and if it sees situations where that need to be enforced, or a conduct that's not compliant, they're going to act on it, because to demonstrate to the industry how serious they consider this obligation and compliance with this obligation. And so in order to get ready for that, you need to have a look at your arrangements and make sure that they work in reality. So it's not just a document. And also you need to make sure that you are keeping clear records of your compliance. So conflicts registers, reporting to senior managements, and written disclosures given to affected parties.
If that's okay, so we've got 4 minutes left. Can I please ask you again, and I'm not meaning to scare you, but more like, after the information that we have provided here, do you feel the same that you felt in the beginning of the webinar, where when it comes, to how confident are you that your current arrangements are fit for purpose? As you can see, big shout out, no names are recorded, so it's just almost for us to know. It's okay. Still a lot of people are very confident, so it seems like the majority is somewhat confident, just as before, but I think we're seeing slightly more movement at the bottom than before, but still the majority is somewhat confident. Thank you. Please keep responding. I'll just kind of wrap it up for you before we close. So what needs to happen is, effectively, the entire industry needs to up their game. So both the product issuers, the advisors, the brokers, everybody, including also, the suppliers to the industry, but effectively everybody in the industry needs to have a look at it and effectively up their game and do what Michaela and Yvonne were suggesting. And here's just a very brief summary. So don't forget, conflicts of interest are not just actual, they're also perceived. And what Michaela is saying, potential, yes, they're potential, but don't forget, we all work with clients, and it kind of matters what our clients think about us, right? So it's also, how do they perceive us? So pub test is a great framework that you can use and very effective. Another one, disclosure alone is no longer enough. I think you've understood that. Management of a conflict of interest must happen in real time. So it's not something that you do 3 months after it happened. You need to have evidence that you've dealt with it as it appeared, or as you became aware of it. And a lot of the conflicts sit in operations, they're not in policies, okay? So that's why we asked you a question, where do you think really in your business does the conflict arise, or has the potential? Then structural conflict, obviously, are particular high risk. So anything that has to do with ownership, incentives, insurer, broker, supplier relations, a lot of potential and a lot of defect or conflict happens there. Here, clear rules on when not to act and walk away. I think Michaela did not kind of hone on this too much, but effectively, if you can't manage it, then walk away and draw the red line when you can't. Okay, so identify absolute cases where you tried, you did your best, and yet you can't do it. So effectively, you're not doing the deal. You're not actually kind of selling or working with someone. And then evidence is everything. I mean, we've heard that already before. So just very, very practical steps. What do you need to comply? So you need to have separate steps for what is identification of the conflict and what is management. So what's the process? Who signs it off? Who decides on it? Who is making the decisions? Absolutely review remuneration frameworks, both the distributors and the product issuers. Absolutely. Audit consent for commission. Just have a look. Obviously, it's for brokers and advisors only, but have a look that you collect that evidence, especially attention AR networks. If you do not know what your ARs are doing out there, it's a big risk for the license holder if you can't prove that they've been collecting that consent before the purchase. Track non-monetary benefits if you're not doing that yet. So it's anything that has to do with gifts, trainings, and so on. Define clear walkaway scenarios. We talked about it. Train staff with examples. That's to Michaela's point, make it specific. Then check incidents and complaints for potential conflicts, because that's where they also live, and then you'll see them there. And finally, clear evidence, not just policies. All right. Apologies. We kind of straight on time. If you have questions or feedback for us, please let us know. We'll do a write-up of this and publish it on the website. And obviously, you'll get your points after this. Thank you for attending and have a great afternoon.